After studying this module, you shall be able to know how a company can be formed, understand the procedure for the formation of the company, learn the various stages of company incorporation, and identify the preliminary contracts.
We shall first discuss the procedure for the formation of a company from the time the idea of forming a company is first conceived till the company is actually formed and commences business may be divided into three principal stages. Number 1, the promotion stage. Number 2, the incorporation stage. Number 3, the commencement of business stage.
We shall now discuss the various functions of a promoter. The main functions of a promoter are: number 1, to conceive an idea of starting a business and explore its possibilities. 2, to undertake detailed technical, economic, and commercial feasibility of the business propositions. Help of experts may be taken for this. To conduct negotiations for the purchase of a business in case it is intended to purchase an existing business. 4. To collect the requisite number of persons, that is, 2 in case of a private company and 7 in case of a public limited company, who can sign the Memorandum of Association and Articles of Association of the company, and also to agree to act as first directors of the company. To decide on some factors such as A, the nature of the company, B, the location of its registered office, C, the amount and form of its capital, D, the underwriters of brokers for capital issue if necessary, E, the bankers, F, the auditors, and G, the legal advisors. 6. To get the Memorandum of Association and Articles of Association drafted and printed. To enter into preliminary contracts with vendors, underwriters, etc. 8. To arrange for the preparation of prospectus, its filing, advertisement, and issue of capital. 9. To pay preliminary expenses. 10. To arrange funds required by the company, including loans.
We shall discuss duties and liabilities of promoters. A promoter can neither be termed as an agent nor a trustee of a company which has not come into existence so far. The reason is that there was no principal or trust in existence for whom or for whose benefit the promoter has acted. But the promoter has wide powers relating to the formation of company. Law has put the relationship of promoters with the company they bring into existence as well as with those whom they induce to become shareholders in it as that of judiciary nature, the relationship based on utmost faith and confidence. Those who accept and use such extensive powers are not entitled to disregard the interests of corporation altogether. They must make reasonable use of the powers which they accept from the legislature, and consequently they do stand with regard to the corporation when formed in what is commonly called a fiduciary relation to some extent. This fiduciary relationship imposes an obligation on the promoters to disclose fully all material facts relating to the formation of company. Although the fiduciary relationship really begins when the company is formed, the fiduciary obligation of a promoter begins as soon as he sets out to act for or promoter of the company. Promoters should not make any secret profits at the cost of the company without its knowledge and consent.
Erlanger versus New Sombrero Phosphate Company, the year 1878. Erlanger, together with some of his friends, purchased an island containing phosphate mines for £55,000. The island was then sold to a new company formed for £110,000. All the 5 directors of the newly formed company were nominated by Erlanger. At the time of the purchase agreement with Erlanger, 2 directors were abroad, while out of the remaining 3 who signed the purchase deed, 2 were completely under the control of Erlanger. Later on, a prospectus was issued inviting the public to subscribe for the shares of the company. The purchase agreement was approved at the first meeting of the shareholders, but they were not told all material facts regarding the transaction. After some time, the company went into liquidation. The liquidator filed a case against Erlanger to recover the profit made by him on account of sale of island to the company. Erlanger defended the case on the plea that the board of directors had full knowledge of the facts. His contention was rejected and he was asked to return the benefit to the liquidator. The court held if the promoters propose to sell their property to the company, it is incumbent upon them to take care that they provide the company with an executive who shall both be aware that the property which they are asked to purchase is the promoter's property, and who shall be competent and impartial judge as to whether the purchase ought or ought not to have been made. They should sell the property to the company through the medium of a board of directors who can and do exercise an independent and intelligent judgment on the transaction. Thus, it is the duty of the promoters to provide the company with an independent board. However, if the board of directors is not independent from the company, as generally is the case, the disclosure to be effective must be to the would-be shareholders as a whole. The disclosure can be made to the members of the purchasing company by its articles of association or prospectus or any other method. If this has been done, absence of an independent board of directors will not invalidate the agreement. Secret profits or undisclosed benefits of any type received by the promoters can be recovered from them by the company. Company can proceed against the promoters for any damage caused to it on account of their fraud or breach of duty. The estate of deceased promoter shall remain liable in any action by a company for deceit or breach of trust if any benefit has accrued to the estate. A promoter can also be liable for any omission of fact stated under Section 56 of the Act or false statement in prospectus as stated under Section 62 of the Act. Remuneration to promoters. The promoter has to incur the initial expenses in the process of formation of a company besides undergoing a good deal of arduous task. The promoter has therefore a legitimate right to claim for both the expenses incurred by him as well as remuneration for the work done by him. The claim for expenses should be supported by vouchers and should be placed before the directors of the company when formed. However, there is no contractual obligation on the part of the company to pay him for these expenses unless the company has expressly agreed upon to pay after its formation for the services rendered by him before the formation of the company. The same is true about his remuneration. The promoter may be remunerated in any of the following ways. Number 1. Promoter may sell his own asset to the company for a profit for cash or shares in the company. He may be given commission on the purchase price of the business taken over by the company. And 3. He may be granted a lump sum as remuneration either in cash or in shares or debentures. The amount of remuneration payable or paid to the promoters is required to be disclosed in the prospectus issued by the company. Let us now discuss the preliminary or pre-incorporation contracts. Preliminary contracts are contracts entered into by the promoters on behalf of the company before its incorporation with third parties. It is usual that the promoters enter into these contracts of purchase of assets on behalf of the company about to be formed, but before it is actually formed. They generally enter into these contracts as agents or trustees of the company which has not yet come into existence. Such contracts are legally not binding upon the company even after it comes into existence. The company can neither ratify those contracts nor sue the vendors on them after its incorporation because ratification requires existence of the principal at the time when the contract was entered into. We shall now discuss the case of N and Company. N and Company entered into an agreement with one C who acted on behalf of a proposed syndicate. Under the agreement, N and Company was to give the syndicate a lease of local coal mining rights. The syndicate was then registered and asked N and Company to give these rights, to which N and Company refused. An action by the syndicate for specific performance of the agreement or in the alternative for damages was not maintainable as a company cannot by adoption or ratification obtain the benefit of a contract purporting to have been made on its behalf before the company came into existence. A company cannot adopt contracts entered into before its incorporation even by passing a special resolution or with the unanimous consent of all its members. Thus, preliminary contracts will either have to be left as mere gentlemen's agreements or the promoters will have to undertake personal liability. Which of these, of course, will be adopted depending largely on demands of the other party. Since the pre-incorporation contracts purported to be made by a company which does not exist is a nullity. Neither the company, when formed, nor the promoter whose signature is added can sue or be sued on the contract. Though a company cannot ratify a pre-incorporation contract, it may make a new contract after it is incorporated to carry into effect a contract made before it was formed.
Liability of the promoter on preliminary contract. The nature of the liability of the promoter on preliminary contracts depends upon the tenor of such contracts. He can be held personally liable if he has purported to act as an agent and the non-existence of the company was known to both parties. This is because where a contract is made on behalf of a principal known to both the parties to be non-existent, the contract is deemed to have been entered into personally by the actual maker of the contract. The case that can be cited here as a reference, the case of Kellner versus Baxter, settled in the year 1866, can be cited here as an illustration. Baxter, a promoter and a prospective director of a company to be formed, entered into a contract with Kellner on behalf of the company. Baxter signed the contract adding the words "for and on behalf of XY Company Limited" on a suit by Kellner. For the performance of the contract, it was held that Baxter was liable as he had contracted on behalf of a principal who did not exist. But if the contract is purported to be made by the company itself, the person so acting. For example, the promoter cannot be held liable personally, for he shall be taken to have simply authenticated the contract, and the company shall be taken to have entered into the contract, and the company being non-existent, the contract shall become a nullity. In case of personal liability, the promoters will continue to be liable until the company adopts the contract. The company will adopt these contracts by entering into a new contract with the third parties on the same terms as were embodied in the original contract. Such a new agreement of adoption may not be expressly made, but may be impliedly made by the acts of the company. In order to avoid their liability, the promoters usually insert a clause in the original contract to this effect that if the contract is not adopted by the company after its incorporation with a limited time, both the promoters and the third party will be exonerated from liability. Some of the promoters simply agree to the draft contract to be entered into by the vendor and the company after incorporation.
Specific Relief Act 1963 provides relief in case of preliminary contracts. Section 15, subsection H and Section 19, subsection E of the Act provide that a contract entered into by the promoters on behalf of the company before its incorporation can be enforced by or against the company if the following two conditions are satisfied. A. If the contract is entered into for the purpose of the company and such contract is warranted by the terms of incorporation, the term "for the purpose of the company" implies that the contract should be for the working purpose of the company. And B. The company accepts the contract after its incorporation and communicates such acceptance to the other party to the contract. We can further illustrate it with the help of a case. Imperial Ice Manufacture Company versus Menchershaw. The promoters of an ice cream manufacturing company entered into a contract with M for the purchase of ice manufacturing machinery for the company. The company on its formation subsequently adopted the contract and sent the communication of acceptance to Mr. M. Held, the contract was for the purpose of the company and was therefore enforceable by or against the company. We will now discuss about incorporation of a company. Incorporation brings a company into existence as a separate corporate entity. The promoter has to take the following steps in this connection. Steps to be taken to incorporate a new company are: the first step is to select, in order of preference, at least one suitable name up to a maximum of 6 names indicative of the main objects of the company, and thereafter ensure that the name does not resemble the name of any other already registered company and also does not violate the provisions of emblems and names, that is Prevention of Improper Use Act 1956, by availing the services of checking name availability on the portal. The third step is to apply to the concerned registrar of the companies to ascertain the availability of name in e-form 1A by logging into the portal. A fee of rupees 500 has to be paid alongside, and the digital signature of the applicant proposing the company has to be attached in the form. If proposed name is not available, the user has to apply for a fresh name on the same application. After the name approval, the applicant can apply for registration of the new company by filing the required form, that is Form 1, Form 18 and Form 32 within 60 days of the name approval. Arrange for the drafting of the Memorandum of Association and Articles of Association by the solicitors, vetting of the same by ROC and printing of the same. Arrange for stamping of the Memorandum and Articles of Association with the appropriate stamp duty. Get the Memorandum and Articles of Association signed by at least 7 subscribers, however 2 in case of private company, in his or her own hand, his or her father's name, occupation, address, and the number of shares subscribed for and witnessed by at least one person. The next step is to ensure that Memorandum of Association and Articles of Association are dated on a date after the date of stamping. The next step is to log in to the portal and fill the following forms and attach the mandatory documents listed in the form e-forms, namely Declaration of Compliance under Form 1, 2. Notice of Situation of Registered Office of the Company under Form 18, and 3. Particulars of the Directors, Manager or Secretary under Form 32. Thereafter, submit the e-forms after attaching the digital signature, pay the requisite filing and registration fees, and send the physical copy of Memorandum of Association and Articles of Association to the ROC. After processing of the form is complete and corporate identity is generated and the certificate of incorporation will be issued by the registrar of companies.
We shall now study about the various documents and forms to be submitted for incorporation or registration of a company. The promoter has to file the following documents with the required fee to the Registrar of Companies of the state, commonly known as the ROC, in which the registered office of the company is to be situated. Number 1. The Memorandum of Association and the Articles of Association of the company duly signed by all the subscribers to the memorandum in such manner as may be prescribed. 2. A declaration in a prescribed form by an advocate, a chartered accountant, a cost accountant, or a company secretary in practice who is engaged in the formation of the company, and by a person named in the Articles of Association as a director, manager, or secretary of the company, that all the requirements of this Act and the rules made thereunder in respect of registration and matters precedent or incidental thereto have been complied with. 3. An affidavit from each of the subscribers to the Memorandum of Association and from persons named as first directors, if any, in the Articles of Association, that he is not convicted of any offence in connection with promotion, formation, or management of any company, or that he has not been found guilty of any fraud or misfeasance or any breach of duty to any company under this Act or any previous company law during the preceding 5 years, and that all documents filed with the Registrar of Companies for registration of the company contain information that is correct and complete and true to the best of his knowledge and belief. 4. The address for correspondence till its registered office is established. Number 5. The particulars of name including surname or family name, residential address, nationality and such other particulars of every subscriber to the Memorandum of Association along with proof of identity as may be prescribed, and in case of a subscriber being a body corporate, such particulars as may be prescribed. Number 6. The particulars of persons mentioned in the Articles of Association as the first directors of the company, their names, including surnames or family names, the director identification number, residential address, nationality and such other particulars including proof of identity as may be prescribed. And 7. The particulars of the interests of the persons mentioned in the articles as the first directors of the company in other firms or body corporates along with their consent to act as directors of the company in such form and manner as may be prescribed.
Next step is obtaining certificate of incorporation. On receipt of documents and the requisite fee, the registrar will examine them and satisfying himself that the requirement of the Companies Act are met, issue a certificate of incorporation in the prescribed form to the effect that the proposed company is incorporated under this Act. On and from the date mentioned in the certificate of incorporation, the registrar shall allot to the company a corporate identity number which shall be a distinct identity for the company and which shall also be included in the certificate. If any person furnishes any false or incorrect particulars of any information or suppresses any material information of which he or she is aware of in any of the documents filed with the Registrar of Companies in relation to the registration of a company, he or she shall be liable for action under section 447 of the Act. Let us throw some light on consequences of certificate of incorporation. Under section 9 of the Companies Act 1956 provides, from the date of incorporation mentioned in the certificate of incorporation, such of the subscribers of the memorandum and other persons as may from time to time be the members of the company shall be a body corporate by the name contained in the Memorandum of Association, capable forthwith of exercising all the functions of an incorporated company and having perpetual succession and common seal, with power to acquire, hold, and dispose of property, both movable and immovable, tangible and intangible, to contract and to sue and be sued by the said name. Thus, the consequences are: number 1, the certificate of incorporation brings the company into existence from the date mentioned in the certificate. 2. It is conclusive evidence of the fact that company has been duly incorporated. 3. It grants legal personality, corporate existence, and perpetual succession to the company. 4. The subscribers to the Memorandum of Association, together with such other persons as may from time to time become members of the company, become a body corporate with a distinct entity from such members having a perpetual succession with a common seal and with the liability of the members limited to the amount for the time being unpaid on the shares held by them. 5. The Memorandum and Articles of Association become binding upon the members and the company as if they have been signed by the company and by each member.
Conclusiveness of Certificate of Incorporation. Certificate of incorporation is conclusive evidence with regard to the proper and regular registration and formation of a company. It cannot be challenged even if irregularities prior to registration are subsequently discovered. It is considered as conclusive evidence even if it was legally impossible that the company could have been properly registered. That is, signatures of all the members were forged, or where instead of 7, only 6 members had really signed, or the persons signing were incompetent to enter into contracts, etc. The date appearing on the certificate of incorporation is conclusive even if it is wrong. The validity of certificate of incorporation cannot be disputed on any of the grounds whatsoever. However, where at any time after the incorporation of a company, it is proved that the company has been got incorporated by furnishing any false or incorrect information or representation by suppressing any material fact of information in any of the documents or declaration filed or made for incorporating such company, or by any fraudulent action, the promoters, the persons named as first directors of the company and the persons making declaration shall each be liable for action under section 447 of the Act. Similarly, grant of the certificate of incorporation to the company will not make the objects of the company legal even if they are otherwise illegal. We shall discuss the concept by studying the case of Jubilee Cotton Mills Limited versus Lewis in the year 1924. On 6th January 1920, the necessary documents were delivered to the registrar for registration. 2 days later, he issued the certificate of incorporation but dated it as 6th January instead of January 8th, the day on which the certificate was actually issued. On 6th January, the company allotted shares to Lewis. It was contended to be void since the company was not in existence on that particular date. It was held that the certificate of incorporation is conclusive evidence of all that it contains. Therefore, in law, the company was formed on 6th January and allotment of shares was valid.
We shall now discuss commencement of business as provided under section 11 of the Companies Act. A company having a share capital shall not commence any business or exercise any borrowing powers unless a. A declaration is filed by a director in such form and verified in such manner as may be prescribed with the registrar that every subscriber to the memorandum has paid the value of shares agreed to be taken by him, and the paid up share capital of the company is not less than rupees 5 lakhs in case of a public company and not less than 1 lakh in case of a private company on the date of making of this declaration, and b. The company has filed with the registrar a verification of its registered office. If any default is made in complying with the requirements of this section, the company shall be liable to a penalty which may extend to rupees 5,000, and every officer who is in default shall be punishable with fine which may extend to rupees 1,000 for every day during which the default continues. Where no declaration has been filed with the registrar within a period of 180 days of the date of incorporation of the company, and the registrar has reasonable cause to believe that the company is not carrying on any business or operations, he may initiate action for the removal of the name of the company from the register of companies.
Let us now recapitulate what we have learned in this module. Promotion is the stage of conceiving an idea of forming a company to do business and working on that idea. Promoters stand in a fiduciary relationship with the company promoted by them. Preliminary contracts may be adopted by a company under the Specific Relief Act. Incorporation of a company requires certain documents to be filed with the Registrar of Companies. Incorporation brings a company into existence. Commencement of business by a company requires filing of a prescribed declaration and verification of registered office of the company.